I'm Mike Hackard with Hackard Law. We work at being one of California's leading law firms handling estate, trust, and elder financial abuse cases. We litigate cases from Sacramento to San Diego. Our heaviest case concentrations are in Sacramento, Los Angeles, and the Bay Area. I've written extensively about what we do. My book, The Wolf at the Door, has been widely reviewed in newspapers, magazines, and the electronic media. Ben Franklin said, either write something worth reading or do something worth writing. I think that The Wolf at the Door is worth reading. I also think that the actions we take for families in estate trust and elder financial abuse litigation are worth doing. Litigation is war. There are battles, raids, and skirmishes. Skirmishes can be a minor dispute or contest between opposing parties. Raids can be daring operations against an opposing party. Battles are longer-term engagements of extended contest, struggles, or controversies. Our more recent skirmishes have involved parties who may agree on their beneficial interest, but have disputes as to the timing of asset distributions. These cases don't evolve into battles if reasonable heads can prevail. Raids may be smaller scale operations. Estate assets not a major part of an estate go missing. Cash thought to be in safes evaporates with some frequency. Battles, major battles, are the largest part of our litigation practice. Deathbed transfers of significant estate assets set off full-size fights. When a trustee engages in self-dealing, some might call it stealing, and transfers millions of dollars of family assets to himself, he puts wrong beneficiaries on the warpath. They're forced to right the wrong. A war may be just or unjust. Classic interpretations of a just war are circumstances where people try to ward off the threat of domination by an opponent or to overthrow an oppressor. It's just to recover assets from an elder financial abuser, an abuser who unduly influenced his Alzheimer's impaired father to transfer millions of dollars of Los Angeles real estate to him, and in doing so, cut off other siblings who were long-named beneficiaries of their father's trust. It's just to recapture property from a trustee who cut her brothers and sisters from their mother's trust so that she could grab millions of dollars in marketable securities for herself. And it's just to pursue a life insurance beneficiary who impersonated a near-death life insurance policyholder to change the holder's child as the beneficiary of the policy to herself. Just war in the litigation context is connected to just cause. Just cause is determining whether the wrong committed justifies litigation as the appropriate response. The examples of wrongdoing that I've given have been or are currently in litigation with the goal of righting the wrong. It might be a court determination or a jury verdict that rights the wrong. However, the harm is ultimately rectified. We, on behalf of our clients, are engaged in battle. In its most classic sense, these battles are longer-term engagements. They're initiated by complaints in a civil or in a probate court. They proceed to discovery operations, the most telling of which have become depositions. Depositions, in a time of widespread video communications, have become trial. Video recordings of witnesses can be viewed by mock trial jurors to assess credibility and likability. The evasive or untruthful witness, marked by mock jurors as deceptive and unlikable, might well determine the ultimate outcome of the actual jury trial. Those cases that don't settle go to trial, a trial that we're well prepared for, a trial that is connected to a just cause. If you'd like to speak with us about your case, call us at Hackard Law at 916-313-3030. We'll be happy to hear from you. Hackard Law, attorneys making a difference.